Good evening, ladies and gentlemen. I'm Vikram Sachdeva, and I'm delighted to introduce this 39 Essex Chambers webinar on the Judicial Review and Courts Bill, which is currently awaiting its second reading. I am absolutely delighted to be able to introduce three legal luminaries to you this evening. First, we have, in order of speaking, Professor Paul Craig, Professor of English Law at Oxford, who they'll all be very well known to you, I think. Secondly, we have Professor Alison Young, who is the Sir David Williams Professor of English Law at Cambridge. And thirdly, we have Professor David Feldman, the Emeritus Rouse Ball Professor of English Law at Cambridge. And you'll see the topics that they're going to be speaking on. There are questions, you can ask questions under the Q&A function, so please don't hold back, and we'll seek to answer those at the end. So hopefully we've got an interesting discussion ahead. Over to you, Paul Craig.
Vikram, thank you so much. It's a great pleasure to be here. Great pleasure to be at one of the 39 Essex Chambers webinars. It's a shame that we can't be there in person, and hopefully that normality will return at some stage. But in any event, my purpose this evening is that I'm going to give some background to the IRL report and give an overview of the two main proposals which concern public law and judicial review, which are contained in the Judicial Review and Courts Bill. I'll then hand over to Alison and David to do the heavy lifting work on the really difficult stuff once I've just introduced it and then retired to the wings, as it were. In any event, I'm going to share a screen and have some slides for you. I apologize that it's not, it seems, going into full screen slideshow mode, but we have tried this and it doesn't seem to avail. In any event, I think that we can move forward. So in terms of the background, we had an IRL press release in which came from the Ministry of Justice, which told us that the government was minded to establish an independent review of administrative law chaired by Lord Folkes, the general brief of which was to consider whether the right balance was being struck between the rights of citizens to challenge executive decisions and the need for effective and efficient government. And more specifically, the review was then told to consider 4 issues set out in the second half of this slide: whether the terms of JR should be written into law, whether certain executive decisions should be decided on by judges, which grounds and remedies should be available in claims brought against the government, and finally, whether further procedural reforms to JR in relation to matters such as timing and standing and the like, and procedural procedures concerned with JR should be reformed. That then got expanded once we had IRL actually set up. That was expanded. Those 4 issues were sort of blown out and beefed up, as it were, in the manner set out here. Very quickly, whether the immunity of public law decisions to JR should be codified by statute. Secondly, the idea of what matters should be left to courts was fleshed out and made more specific by question 2, whether the legal principle of non-justiciability required clarification, and if so, whether there were areas where the exercise should be regarded as non-justiciable and whether the range of those areas should be reconsidered by the government. And then issue number 3, whether in circumstances where the exercise of a public law power was justiciable, whether there should be greater consideration or further consideration concerning the grounds on which the court should be able to find a decision to be unlawful, and whether more detail could or should be provided in terms of a correlation between the nature and subject matter of the power and the grounds for judicial review, and further consideration about the range of remedies available for breaches of certain kinds. And then fourthly and finally, there were a range of more specific considerations concerned with the back end of the matter, the purely remedial end of the matter, which doesn't mean it's not important, it is very important, about things such as standing, the duty of candor, timings, possible changes to rights of appeal, and the like. Now, as most people in this room will know, in this virtual room will know, the IRL panel generally came out against significant changes relating to the issues that it was asked to consider. It came out against codification. It didn't believe that codification of the kind that exists in some other legal systems could meaningfully be undertaken in a common law system such as the United Kingdom. It was also doubtful as to whether there could or should be any general changes in relation to the second issue, which concerned justiciability. But it did recognize that Parliament might legitimately legislate in relation to justiciability, or an issue on which it thought there was an issue concerning justiciability on a particular issue or on a particular occasion through the use of an ouster clause or some other technique. The panel was equally skeptical concerning legislative intervention in relation to whether there should be some statutory tailoring of the grounds of intervention and the subject matter of the case. It rightly, in my view, concluded that the courts already do this to varying degrees, and that there would be very considerable difficulties in legislating in this regard. And also on a number of the important, as it were, procedural matters concerning changes to rules of standing and time limits, it did not believe that change in that respect was warranted. It did come out, however, with two more specific recommendations which have been taken up and developed. The first was that CART-JR applications should be stopped, or that there should be detailed consideration as to whether they should be curtailed, given the high number of such applications, the resource implications thereof, and the very low incidence of success. And the other recommendation that it came out with, and these are in the respective paragraphs of the IRL report, is that the court should be accorded power to make a suspended quashing order SQA, which would automatically take effect when certain conditions were met. The MOJ then responded to IRL in CP 408, and it welcomed the IRL report, but then basically, if you want to use this metaphor, picked up the baton, as it were, and headed off round the track of its own making, and it set in train a second round of consultation. The range of questions posed was far-reaching. So the MOJ included in this second round a range of more specific inquiries concerning suspended quashing orders and prospective-only remedies, but it also raised far-reaching issues concerning matters relating to nullity and ouster clauses. At the end of the day, the MOJ decided in the Judicial Review and Courts Bill, which is currently going through Parliament, to concentrate on remedies. And very briefly, and Alison and David are going to pick this up. And so I'm just doing the introductory show here. The two issues are about suspended quashing orders, which, if the bill goes into law, will be introduced via a section 29A of the Senior Courts Act 1981. And the key takeaway points about section 29A, which Alison will, I'm sure, develop in more detail, is that on the one hand, there's a discretion. It empowers courts to make an SQA, and it can either make provision for the suspension not to take effect until a specified date, or remove, limit any retrospective effect of the order. And the SQA can be made subject to conditions. And if an SQA is issued, then the impugned act is upheld until the quashing takes effect, assuming that it does take effect. That's all a rough paraphrase of 29A 1 to 6. There is a broad list of considerations which Alison is going to amplify for a court to take into account in deciding whether to issue an SQA, and those are set out in 29A 8. There is, however, a mandatory sting in the tail, which is provided in 29.8. Sorry, in 29, I think it's 10, if I'm not wrong, or 9. I've now forgotten, I apologize. But the bottom line is, if the court is to make a quashing order, and it appears to the court that an SQA, quote, would, as a matter of substance, offer adequate redress in relation to the relevant defect, then the court must make such an SQA unless it sees a good reason not to do so. So you have a mandatory sting in the tail. The court is still left with a discretion, but the discretion is, as it were, turned about face, so that there is a prima facie duty subject to a get-out clause, whereby the court can decline to make an SQA if it sees a good reason not to do so. So the removal then of JRs is the other initiative contained in the bill. It's to be introduced by an amendment to the TCEA, excuse me, a new section 11A. Now, basically what this does is it renders a decision of an upper tribunal final in relation to its decision to refuse permission or leave to appeal pursuant to section 11.4b. People in this webinar will know that, in effect, what Cart and the Supreme Court had done was to say that in circumstances where a first-tier tribunal and the upper-tier tribunal both, in effect, said you couldn't have any further appeal, and that the upper tribunal wasn't going to hear the appeal from the first-tier tribunal, there could then be JR from of the upper tribunal's decision. And that is what is now being reversed by the Judicial Review and Courts Bill. That was felt, and I'm sure we'll have discussion about whether this was warranted, that was felt to be an undue taking up of judicial resources, given the very limited success rates of these cases. So it's backed up by an ouster clause, and this is one of the things I'm sure David's going to be talking about. And the ouster clause is in what will be 11A 2 and 3 and 6, and it's subject to limited exceptions. And this is, if one may put it this way, a legislator's belt and braces job in the following sense. The ouster clause is. So 11A2 tells us the decision is final and not liable to be set aside in any court. However, as public lawyers in this room will know, a finality clause by itself per se would not be successful in excluding judicial review, and there is long-standing jurisprudence about that. So the legislative draftsman has then, what they have then done is to supplement 11A2 with 11A3, and 11A3 is itself double-headed, as it were. So one part of 11A3 is saying that the upper tribunal is not to be regarded as exceeding its jurisdiction by reason of any error made in relation to the decision. And then the other part of 11A3 is saying the supervisory jurisdiction does not extend to, and no application or petition for judicial review may be made in relation to the decision. So 11A2 and 11A3 are kind of the belt and braces of this ouster clause. 11A6 is in effect a further part of the ouster provision, because that 11A6 is really is saying you can't circumvent the above through seeking JR of the first tier tribunal's decision. And I leave it to David to take all that forward in his own presentation. Just before I pass over to Alison, it was agreed that I would say just a word or two about the other limb, as it were, of the government's investigation and reform about public law, which is the Independent Human Rights Act review. Its report is imminent, end of October, according to the MOJ website. It has nonetheless been, and what the content is remains to be seen. However, it has to some extent been preempted by the new incumbent in the Ministry of Justice, Dominic Raab. Now, what transpires, whether this affects the report of the Independent Human Rights Act review remains to be seen, or perhaps we'll never know. But they nonetheless indicate Dominic Raab's desired direction of travel, and they merit some brief consideration here because they're important. There are two strands to what Dominic Raab was saying in his Sunday Times excursus into what he thinks should be done in relation to this area. First of all, there was an emphasis on the possibility of ad hoc legislation to overturn HRA decisions that the government dislikes, or indeed, I mean, it's not entirely clear, but I think that the idea of ad hoc legislation also includes the possibility of ad hoc legislation to overturn ordinary non-HRA JR decisions, which the government dislikes. So a couple of brief words about this. It is, of course, axiomatic, and it's always been axiomatic, that Parliament can do this. It's sovereign, and thus it's always been able to do it. This is not new, okay? Parliament's sovereign in our system. If it wants, through the exercise of its sovereign will, to overturn a JR decision or an HRA decision, it can do so. So the very fact that Dominic Raab is emphasizing this, there's only two logical possibilities here. One is that the government, on his view, should make greater use of that power. That's one possibility. Though I say, and happy to discuss this further in the Q&A, the actual framing of specific primary legislation to overturn a particular HRA decision or JR decision may be a little bit more difficult than one thinks. The second possibility is the scary one, and that is that the government enacts primary legislation to render it easier for the government to do this in the future. One could imagine the possibility, scary constitutionally though it would be, of a Henry VIII clause put into primary legislation, which empowered the overturning of an HRA decision made by the courts or a JR decision through secondary legislation, and not only overturning the JR decision or HRA decision by secondary legislation, but also potentially overturning primary legislation that underpinned the relevant judicial decision. Now, I think that would be constitutionally novel, and I think it would be wholly unwarranted and very dangerous. Finally, and then I will pass over to Alison, the other strand of the Minister of Justice's iterations concerned Strasbourg. So this was, the intent here was to kick against Strasbourg, the indication being, or the message of travel here being that the government would seriously think about weakening the force of Strasbourg decisions on UK courts. Again, it remains to be seen what the government actually does. But again, there are some concerns and problems in this respect. First of all, as pretty much everyone in this webinar will know, Section 2 of the HRA is already framed in terms whereby UK courts take account of Strasbourg decisions. They are not formally bound by them as a matter of precedent. It is not exactly clear how that could be weakened further while the UK remains a member of the ECHR. The second point to bear in mind is the following. The court's case law on Section 2, or built on Section 2, the mirror principle, reveals 2 points that are salient for these purposes. Firstly, the UK courts already do push back on Strasbourg case law where they feel that this is warranted. And they have done this on a number of occasions where they feel that the Strasbourg decision is internally unclear or misunderstands the nature of the common law system. And they have not been wary or chary of pushing back in those circumstances. It's also true, as people will know, that they are willing to treat the Strasbourg case law, or they have been, and in my view rightly, as primarily a floor and not as a ceiling. In other words, they've been willing to go beyond the Strasbourg case law where they feel that that is warranted, even if there is not a particular Strasbourg precedent that governs the case at hand. However, UK courts remain strongly inclined to regard ECHR case law as a flaw, which generally should not be departed from. And they do so, again, for sound reasons. We are bound by the ECHR. And while we are bound by the ECHR, if the UK courts choose not to follow a clear line of Strasbourg precedent, not only will they be in breach of the ECHR, litigants will then simply take their case onwards and upwards to Strasbourg. It remains to be seen how the IRA panel, what it actually says, and it remains to be seen how the government takes HRA reform forward. Thank you very much indeed.
Thank you very much, Paul. Over to you, Alison.
Thank you. So I'm hopefully going to share my screen now. And hopefully that means you can now see my slides. Well, I can see them, so hopefully everyone else can as well. Well, thank you very much, Vikram, for inviting me, and Paul also for that excellent introduction. I'm in the very fortunate position of being able to continue pretending I'm both at Oxford and Cambridge, because I get to continue working with both Paul and David, which is fantastic. So thank you very much for that alone. What I would like to do is to build on the idea of suspended quashing orders and prospective only remedies, and dig down a little bit into what they mean and how I think the courts might interpret them in the future. And of course, yes, there we go. It's just being slow. So what I'd like to focus on at the beginning is just to kind of have a look a little bit more about what the discretionary power is and what the mandatory component is. And with regard to the discretionary power, I'm broadly happy with this. I think this could be a change where we could see the courts being given more discretion to remedies, and it could be a situation in which we see a kind of change for the good, which gives an element of flexibility while still being able to protect the rule of law. And so I kind of broadly welcome the change. I think it also fits in with some way in which we can see some recent Supreme Court cases moving. And by recent, I mean a month ago and last week. So we're starting to see cases coming along that are recognizing this idea of flexibility in remedies. So I think it's something the courts will use and might give an ability, perhaps even, you never know, in some instances to provide stronger remedies than we might have otherwise had. There might be some situations in which the court will think, well, I'm not sure I want to give a quashing order here. And beforehand, I might have just given a declaratory order, but maybe a suspended quashing order might be the way forward here, or maybe a prospective only remedy. And that might be better than just having a declaratory order. But my optimism, as ever, is tinged with a note of caution. And that is, will it also be used in certain circumstances where it actually is there to weaken remedies writ large? And if so, how can we try and prevent that and make sure we still have a range of good and effective remedies in judicial review? And that takes me on to the mandatory component, where I'm sort of start off being pessimistic because I don't like the mandatory component. I think it's much better to have a discretion rather than to have this idea that you're required to give a suspended or prospective only remedy in certain circumstances. And my tinge of optimism in response is I actually can't see the courts seeing it as that mandatory. And so I think building on, in particular, the way in which we can see the interpretation of the reforms of 2015 reforms, which modified Section 31 of the Senior Courts Act 1981, I can see the court sort of reading this in a way that is more likely to give stronger remedies and less likely to require weaker remedies in certain circumstances. So what are these lovely discretionary criteria? So I've tried to set them out on your slide there so you get an idea of the factors the court are meant to take into account when they're exercising their discretion to give either a suspended quashing order or a prospective only remedy. And as you can see, it's beautifully broad. So you have the nature and circumstances of the defect, any aspect of detriment to good administration, the interests or expectations of persons who benefit from the quashing order, the interests and expectations of people who relied on it, so far as it might be relevant, any kind of action or proposed action that a public body has undertaken in response to this particular illegality, and just in case you've missed anything out, any other matter that appears to the court to be relevant. So you have a wide range of circumstances that the court can take into account here, mostly thinking in terms of what was the defect, what is the impact going to be on the parties and third parties, and are there any kind of remedies that we think might be brought in response to this. So it's I think it's the right kind of features. I think it will give the court a large amount of discretion and hopefully will enable them to think carefully about when we do or do not need a suspended quashing order. So how do I think this fits with Supreme Court decisions? Well, my two recent decisions are RTN Vietnam and Secretary of State for the Home Department, and the one from last week are Majera. and Secretary of State for the Home Department. You might see a theme here. The Secretary of State for the Home Department seems to be where we get these statements to do with nullity. And in both of these cases, you can see an element of flexibility in the extent to which the courts will grant remedies. So in TN Vietnam, we had the difficult situation of decisions that had been taken by tribunals on immigration issues that had been taken through a specific fast track procedure. And this fast track procedure was itself seen to be unlawful because it was giving rise to unfairness. Specifically, when you're dealing with a general rule, you have to show there is substantial risk that when you apply that general rule, you will end up with unfairness. So the question that then arose was, well, if the process was unfair, did that then mean that every single immigration decision that had been taken applying this now deemed to be unlawful process would also be unlawful and so would therefore have to fall? And the answer for the Supreme Court was no. And there were two different reasons why that wasn't the case. One is to kind of see it almost as a chain of causation. Just because there's a substantial risk of unfairness that general fast track procedures, that doesn't mean that every single time you apply that fast track procedure, you'll have an unfair decision. So instead, rather than it being void and every decision falling, it was voidable. You go to the court and say, it was unfair in my situation, so you should quash my particular decision. And the second argument was to say, well, what is the jurisdiction of the tribunal when applying these fast track rules? Its jurisdiction comes from the Immigration Act. It has the ability to take these decisions. We read into that an implied condition that will only take these decisions in situations which are procedurally fair in the individual case. Therefore, it's only unlawful if it was unfair in your case. That's the only situation in which the Immigration Tribunal would not have jurisdiction, leading to the same conclusion. It doesn't automatically quash. You have to go to court and say it was unfair in my particular situation. So you can see, regardless of whether you're going down traditional nullity grounds or not, the answer is it's not going to fall automatically. There is some discretion built into the system. Similar situation arose in Majera, this time to do with a bail condition. So we had a court order setting bail, and then we had the Home Secretary then adding on some extra conditions to this particular bail decision. And the question became, could the Home Secretary add on these extra conditions? And the Home Secretary said, well, I'm not adding on extra conditions to this bail decision because the bail decision itself was unlawful, and these conditions I'm imposing are being imposed on you through different powers. And the problem arose because there was a court order granting the bail, but the Home Secretary didn't bother bringing judicial review to the court order. They just decided to add on extra conditions. So the question was this original bail conditions, were they void ab initio, even though there hadn't been a court order declaring them to be void ab initio? And essentially, long story short, the Supreme Court said they're not void until you've had a court order telling you they're void. And then, so you couldn't go away and say it was void ab initio, you had to have the court order to quash it, and then you could go away and deal with other conditions afterwards. You couldn't decide not to bother quashing it. But what's important is this paragraph 32 that I want you to think about, which they're basically saying, yes, we can think about these binary distinctions between void and voidable, but really it's much more fluid than that. It's not just about borrowing these binary terms. There's much more flexibility in the remedies that we grant in certain situations. So here, obviously, you can't just ignore a court order. You've got to go away and challenge it. And then rather than saying, well, I think it was unlawful, so it must have been void and I'm going to ignore it, you need more flexibility. And there's a stress on the need when you're thinking about remedies to think about the concepts underpinning the jurisdiction of the court, things like legal certainty, orderly administration, and respect for the rule of law. So you can see this flexibility in these cases. So I think granting flexibility in legislation, I think, will be picked up on and used by the courts. Why do I think you might get stronger remedies? Well, my possible example is the Plan B Earth in the Court of Appeal. I know it didn't succeed in the Supreme Court, but let's just focus on what happened in the Court of Appeal, where you had this argument that they hadn't fully complied with the legal requirements because they should have taken the Paris Agreement into account when developing this particular planning scheme. Well, this was a procedural detriment. And the remedy that was granted in Plan B Earth was a declaration. So you had a declaratory order to say that they should have taken this into account. But are those the kind of situations where the court might say, well, maybe we should say, we will quash this decision. So we're going to give you 6 months in which to go away and take this into account and decide whether you want a different planning scheme. And if not, we'll quash it. And that could give extra force while still recognizing the fact that you might not want to quash a decision because of all the necessary consequences of quashing a particular planning decision in this area. So it makes me wonder if this might provide an opportunity in these procedural defect type cases for the court to perhaps think more flexibly rather than going down a declaratory order, because I think there are good reasons for only giving a declaratory order. Might they instead be tempted, or might barristers be tempted to argue for a suspended quashing order in these types of situations? And might that provide, perhaps in some circumstances, a better remedy? How do I think these might be interpreted? Well, if we look at our flexible criteria, they are quite broad. And I wouldn't be surprised to see courts picking up on these principles that we see stated in Majera, or at least this being argued by barristers, that when we're interpreting the new section 29A8 or whatever it's going to become, what we will do is we'll draw on these background principles of legal certainty, orderly administration, and respect for the rule of law, because these are reflected in the criteria. So we're thinking about legal certainty by thinking about the detriment to individuals and third parties. We're thinking about orderly administration by thinking about, has the administration done anything in response? We're thinking about respect for the rule of law by thinking about an adequate remedy for the parties before the court. So I can see these principles being used perhaps, or at least arguably being there to be used to work out how you're going to interpret this future section if it comes in as written in the draft bill at the moment. So possible situations where this might apply: situations like Ahmed, where a suspending quashing order would have meant, rather than being in breach of the rule of law by being in breach of international law obligations, we would suspend it, allow the court some time to go away and the administration some time to modify it, and then it would be quashed in the future, rather than quashing it and having retrospective legislation. So this might be a better solution in those types of scenarios. Might be useful in situations like TM Vietnam, where you have this domino effect. So you could say, well, in addition to you have to go to the court to say it was unlawful in your situation, if you think there's such a problem with the general measure, you could also say, oh, and by the way, we're going to give you so long to go away and come up with a new procedural rule, and if not, we're going to quash it and they'll all fall. So that might be useful in those kinds of scenarios. What I'm worried about is it might also be deemed to be useful in the kind of situations that we saw in the Riley and Houston case, where you had a challenge to particular benefit situations and whether you how many hours you had to work to claim benefits. And because this would cost a huge amount, the government decided to intervene between the decision of the Court of Appeal and the decision of the Supreme Court and bring in some measures to make it lawful. And this obviously was seen in the later High Court 2014 High Court case as being one of the few areas in which you couldn't have retrospective measures, and so it was declared incompatible with Article 6 ECHR. And that makes me worry, is this what the government is thinking about? Those situations where a remedy would be economically costly is when we should have prospective only or suspended. And if so, how can we use arguments relying on the rule of law to perhaps resist the temptation to have suspended or prospective only remedies in those situations? What about the mandatory requirements? Well, I'm not particularly happy. I don't think most of us are particularly happy with these, because it's much better to see this as a discretion than to say you have to do this in certain circumstances. So I think these are seen as problematic, not just because they remove discretion, but also because they could have quite a large impact on remedies if you pushed into a situation where the courts are constantly having to grant suspended quashing orders or prospective only remedies. Why am I not as worried as I might otherwise be? Because drawing on the way in which the courts interpreted sections 31(2)A to 2C of the Senior Courts Act, I think the courts are likely to do something similar, to draw on background aspects of the rule of law and to kind of read down this. So I think you'll find that there'll be very few situations in which it would be an adequate remedy to have a suspended quashing order or a prospective only order. We could use these criteria that we talked about to think about only in those situations where it might undermine the rule of law or where there's very, very serious domino effects. And I can see quite a lot of satellite litigation going on about when it will and will not be an adequate remedy in order to kind of firm up these criteria to push when it will only be when it's adequate in these circumstances. I think the other thing the court will do is it will build on the exception of it being in the public interest to grant a quashing order anyway, in a similar way that the court have relied on the exceptional public interest exception in certain circumstances to get out of sections 31(2)A to 2C. And again, the other case I've given you where you can see the courts focusing in this way of sort of reading down to A to 2C is the Plan B Earth in the Court of Appeal, where you have this focus on the importance of the rule of law. And this was used to read down to A to C and also to broaden what we meant by public policy exception. And I can perhaps see the courts doing similar things when we go away and look at our mandatory requirements by going away to say, well, drawing on the rule of law, it's going to be very few circumstances in which this would be an adequate remedy. So reading down when 9B applies and building up when the court sees it a good reason not to apply a mandatory suspended quashing order. That's much broader than an exceptional public policy interest that we saw in 2A and 2C. So I can see the courts perhaps being tempted to read that quite broadly and sort of narrow the impact of the mandatory requirement. The downside of that is that might then be perceived as the courts not doing as they are told, and we end up with another round of IRAL. But well, that's probably 2 years' time rather than what's going on next year. So I'll leave it there and hand over to David.
Thank you very much. I'm very grateful to Paul for introducing the subject in ways that make it much simpler for me to talk about the ouster clause issue, and to Alison for her review of the other provisions. And it's a great pleasure to be here once again. The ouster clause provisions are in some ways very straightforward. We start from the position that ouster clauses excluding the jurisdiction of the High Court to supervise other courts and tribunals, such clauses are constitutionally suspect. And they're constitutionally suspect not only because the rule of law requires, at least to some degree, that people should have access to independent courts and tribunals to determine the legality of behavior and decisions affecting them. But also, as we learnt from the Supreme Court's judgment in the Privacy International case, that the courts regard there as being a potential inconsistency or illogicality in parliamentary sovereignty saying that Parliament can make any legal provision it likes, but then having other legislative provisions saying that the misuse or misinterpretation of those provisions by officials and other bodies that misinterpretation is to be free of any sort of judicial control. So we have the courts in a position of both upholding the right of access to courts by adopting a narrow, where possible, narrow interpretation of these preclusive provisions, and also upholding parliamentary sovereignty by making sure that the word of Parliament, the legislative provisions are properly interpreted and given effect. Now, when are these provisions more suspect than others? And it became clear in the Privacy International case that some provisions are likely to be more suspect than others. But unfortunately, Privacy International provided us very little clear guidance about what principles were to be used in deciding how much effect or how much interpretive leeway there should be in relation to preclusive provisions. So let me start, before looking directly at the provisions in the bill, by setting out what I think are some of the underlying legal principles which now, up to now, have been regarded as governing the interpretation and implementation of these provisions. First of all, there is an interpretative element. The idea is principally that they should be interpreted in accordance with the requirements of the rule of law for access to court to be maintained. And to that end, there is a general requirement, although perhaps a rebuttable one, that people should be able to test the lawfulness of behavior affecting them. There is a presumption which flows from that legislation isn't to be regarded as intended to exclude the supervisory jurisdiction of the ordinary courts. And that's a presumption which at least some of the justices, I think 3 in total, regarded as a very strong one in the Privacy International case. There's a principle, and this is again an interpretive principle, that any legislation which is going to have any chance of excluding the supervisory jurisdiction must be in the clearest possible terms and must be, as far as possible, unequivocal if it's going to be given any effect. Going beyond that, there is a constitutional argument which was accepted in, at least hypothetically, to a greater or lesser extent by the justices, 6 of the 7 justices in the Privacy International case, that in some circumstances, it may be outside the legislative competence of Parliament to legislate for the removal of the supervisory jurisdiction of the courts over certain types of decision in certain kinds of circumstances. It isn't entirely clear what circumstances those are or what kinds of decision by what kinds of body that might apply to. All that was agreed was that we haven't ever yet had a case where that constitutional rule is likely to come into operation. So let's turn against that not very satisfactory background to the clause of the bill which introduces a new section 11A to the 2007 Act, the Tribunals Court Enforcement Act. We can focus on a number of features of the Act and ask ourselves, first of all, is this clear and unequivocal enough a move to exclude review? And secondly, is it one which is likely to run into constitutional problems, given the context, the type of decisions that are in play, and the general feeling about the importance of access to court under the rule of law? First of all, we note that in some ways it's a very wide exclusion. It expressly includes not just decisions, but also purported decisions to start with. This avoids the argument that it doesn't apply where a decision is ultra vires or a nullity, whatever that may mean at the moment. Secondly, there are a series of roadblocks, different roadblocks set up in the way of someone wanting to challenge a decision about the giving or refusing of permission to appeal from the upper tribunal. One is that the decision is said to be final. Well, that gets us not very far, as Paul said, and likewise not liable to be questioned or set aside in any court. Well, that takes us back to the anisminic type of reasoning, which didn't work particularly well in anisminic. Secondly, there's a roadblock to challenges on the ground of excess of power, because subsection 3 of proposed section 11a says, first of all, that the upper tribunal is not to be regarded as having exceeded its powers by reason of any error made in reaching its decision. And the supervisory jurisdiction does not extend to, and no application or petition for judicial review may be made or brought in relation to this decision. So the body, the upper tribunal, can't be regarded as having exceeded its powers. And then the third roadblock is that the supervisory jurisdiction is narrowed so that the High Court doesn't have jurisdiction under the supervisory jurisdiction to entertain such challenges. And to this, we also have, as Paul pointed out, subsection 6, that you can't get around this by trying to review the first tier tribunal instead of the upper tribunal. So we have a belt, braces, and something else, belts and 2 pairs of braces, at least maybe 3 pairs of braces approach, which is reminiscent of and probably informed by the provision in the 2003-4 Nationality and Immigration bracket treatment of claimants, etc., close bracket bill, which never got enacted in this form, but which caused great unhappiness among lawyers, partly because, perhaps largely because, it was thought that if any provision of this kind was ever going to be effective, this was it. Pretty good, really. The only thing that it hasn't done is to say, and what is more, in this matter, the upper tribunal is the arbiter and the only arbiter and the final arbiter of the scope of its own power and jurisdiction. So how likely is it to be effective? Well, I actually think this is very likely to be very effective for a number of reasons. First of all, I don't think judges will regard this as a major issue of principle. It's concerned with a procedural matter rather than a substantive legal matter. it is a situation where access to court or to an independent tribunal isn't being cut off, because all parties of this kind will already have had at least one merits hearing in the first tier tribunal and or in the upper tribunal, either in by way of appeal or review. The judiciary doesn't like the consequences of its own decision in CART anyway. It doesn't like being overwhelmed by what, on average, I think IRL found something like 700, 800 applications a year for judicial review based on CART, most of which, the vast majority of which, probably all but about 1% of which, have no chance of leading to any successful conclusion, maybe less than 1%. Waste of resources. And one thing we know about the rule of law from CART itself is that the rule of law in this context is a double-edged sword. On the one hand, it requires access to court, but on the other hand, it requires the proportionate use of judicial resources, because if courts and tribunals get completely overwhelmed, that will severely hinder the ability to protect the rule of law for litigants in general. So we're told that it must be made available proportionately. And this will not be regarded as a particularly strong case for courts to pick a battle over preclusive clause. So there are other considerations as well. There is I think, no lack of clarity in the drafting of this as to what's intended. And if you look at the Privacy International judgments, they compared the preclusive provision which was in action in that case with the draft that had been put into the Nationality and Immigration and so on bill in 2003, and said the one in this act doesn't measure up to, in its clarity, to that one, and that in some strange way was regarded as a good reason for not giving effect to the one that they were faced with. Lastly, in some ways, it's a much narrower exclusion than one thinks from the headline. First of all, it is a prospective ouster only. It doesn't apply to cases which relate to decisions of the upper tribunal before this amendment would come into force. But more important, the review for what I think of as old style or strong lack of jurisdiction, sort of failure to have power to get within your jurisdiction at all, is preserved. You can still have judicial review under the proposed section 11A on the ground that there's been no valid application before the upper tribunal when it made its decision, or that it wasn't properly constituted to make the decision at the time when the application was decided, or, and this goes a little bit wider, that it was acting in bad faith or in fundamental breach of the principles of natural justice, whatever a fundamental breach of the principles of natural justice may be. So that's in proposed section 11a subsection 4. Now, when you think about that, it makes it a really rather well-balanced provision. It means that it protects judicial review in circumstances where the tribunal has gone seriously awry procedurally on its capacity to make a decision or the way it goes about it. And it also preserves at least some protection for bad faith and breach of natural justice. Of course, it'll be very interesting to see how that term fundamental breach of the principles of natural justice is interpreted. Does it mean a really serious breach or a breach with really serious consequences? Does it apply to the old-fashioned rules of natural justice, or does it apply also to the extended duties of fairness which have supplemented them over the years? We shall find out, no doubt. So it seems to me that there's not going to be a great incentive for the High Court or the above to be terribly resistant to this proposed ouster. And I think it's utterly inconceivable that a constitutional challenge on the ground that this was a serious denial of the rule of law or of parliamentary sovereignty has any chance of success for similar reasons. So I think this is going to work. I don't think it'll have any great immediate effect. I think advocates will use a good deal of ingenuity to try to bring their cases within the exceptions. I think gradually they'll fail. One of the things that will happen as courts deal with this is that they'll be encouraged to elaborate the sort of emerging approach to jurisdiction and nullity and the relationship between errors of law and nullity that Alison was discussing in relation to TN Vietnam and the recent Majera judgment. But I think it'll work in time, both legally and practically. One last point, if I may, before I go. Alison suggested to me before the webinar that it might be worth considering how the general approach to drafting and interpreting ouster clauses might apply to another ouster clause. For example, the one in the bill which is now, another bill which is now before Parliament, the Dissolution and Calling of Parliament Bill. The purpose of that bill is to repeal the Fixed Term Parliament Act and to revivify the royal prerogatives to dissolve Parliament and to summon a new one. And that is protected in that bill by a provision that says a court or tribunal may not question A, the exercise or purported exercise of those prerogative powers, B, any decision or purported decision relating to those powers, cutting out decisions about advice to Her Majesty on the exercise of the dissolution prerogative, for example, or C, the limits or extent of those powers, so cutting out a vires and challenge. And what is clearly worrying them is the risk that the sort of approach the Supreme Court took to the prorogation case, Miller number 2, might be applied in a future case to a dissolution. Now, again, this is a much more constitutionally significant issue than the one in the Judicial Review and Courts Bill. On the other hand, it is very clear, even though it doesn't follow in detail the model of the Nationality and Immigration, etc. bill. But I think on balance, because it's such a political issue, I think courts would be willing to say, well, this isn't really our sort of field anyway. And so it's not wholly unreasonable or a breach of the rule of law for us to be prevented from sticking our oars in. On the other hand, just consider what would happen if a Prime Minister were to advise Her Majesty to dissolve Parliament, not in order to hold a general election and summon a new Parliament, but in order to usher in an extended period of executive government without parliamentary scrutiny or constraint. And suppose that advice were to be challenged, and the Prime Minister would say to the court, well, look at this preclusive clause. You can't do it. You can't interfere because of the ouster clause. I think that might just be very much the sort of case where the constitutional challenge might come into play, because the courts might regard themselves, as they did in Miller 2, as guardians of a model of the Constitution which is essentially representative parliamentary democracy, and say, excluding the court's power to protect the Constitution, a fundamental of the Constitution in these circumstances, is actually beyond the power of Parliament. It would be an interesting argument to make. I wonder. Thank you.
Thank you very much indeed, David, and indeed all three of you for very interesting presentations. We do have some questions. The first is, do you agree in the first place that CART JR should be removed? I think David has expressed his view already, but what about the other two? Alison, what do you think?
Thank you. I'm probably one of the few academics with some misgivings about removing CART JR. So I do get the ins and outs of the fact that this is perhaps a waste of judicial resources, that you do have to balance what types of review you do permit and what you don't. And I also accept that by this stage, there's normally some, it's not as if you're saying this is a decision of the executive that's not being reviewed. This is a decision of a judicial body that then will not get judicial reviewed. It's technically part of the administration, but it's constructed in exactly the same way as if it is a court, and is very similar in terms of its composition in some senses, but particularly in terms of its function. So I guess my only slight misgiving is the extent to which there needs to be some kind of backstop for what happens if the tribunals go completely and utterly rogue. I mean, it's not going to happen on a regular basis, but in exactly the same way that David was hypothesizing about what if the Prime Minister decided we're going to dissolve Parliament, not have a general election and bring in a whole load of executive government and goes rogue that way. Could you have a situation where you had important human rights through immigration decisions in particular that weren't being protected, and so therefore there needed to be a review? And I think in those circumstances, the exceptions that David was pointing to might be enough to rescue that kind of element of constitutional backstop. So I think my concern is, maybe I just need lots and lots of pairs of braces and belts when it comes to constitutional design, because I just don't trust anyone. And so if I think there's any way of making sure there is some form of backstop just in case, then I would like that. And maybe the 11A4 is enough to preserve that if you have situations in which you think, particularly in cases like immigration, where you think human rights have not been protected properly in certain situations, and then there's a consistent pattern of not allowing appeal on that point, there might be very good reasons for allowing that to go up to the Supreme Court, allow a reinterpretation of human rights decisions that can then filter down in immigration cases. So that aspect of CART is something I think might need preserving. And I guess my question is how far 11A4 would preserve that.
Paul, what do you think of CART?
Thanks, Vikram, and thanks to David and Alison. I'm somewhat equivocal about this. I mean, I can see the arguments for going down the road that the government is minded to go down. I really can. I think my concerns are, to some extent, have been expressed by Alison already, but just to express them in my own terms, I would put my concerns in the following way. I think there are two, possibly three kinds of concern. One is that there's been interesting academic and empirical work which has been done, which has actually questioned the empirical basis on which the government is acting, questioned whether these cases are such no-hopers, and questioned whether the fail rate is as bad as has been posted, as it were. And there's been some really interesting work done on that.
I think 3% is the new figure, isn't it? The government's given a new.
Well, yeah, but there's been another interesting paper which is actually, it's not just question the 3% figure. There's another interesting paper which has been, which has looked at the way in which these decisions are made within the tribunal system. In other words, it's digging deeper and looking at the way the decisions are actually made within the tribunal system and questioning whether they've been, in a sense, given as much or as thorough consideration within the tribunal system as one might have thought. And so, in other words, the background premise to the whole assumption behind the CART reasoning is, well, you've had your day in court, as it were, before the FTT and the UT has had a look at it and decided, no, you don't get an appeal and all that, and tough, or, done, rule of law satisfied. And some people who've looked at this said it's actually not quite that simple. So anyway, but look, I haven't looked at that stuff in detail, but I'm merely saying that's one kind of concern. I think the second point to make is that while I take everything that's been said about this, my second point is that I'm still somewhat puzzled about why there has been such a problem with CART applications in a post-CART world, in the sense that CART made very clear in the Supreme Court that you didn't get to raise a JR action. You didn't use normal tools of judicial review, that the remit for judicial review was much narrower. Now, given that that's certain, they've specified it was the section 13.6 kind of criteria from the TCAEA. So one of my puzzles, now I'm not in practice, so I don't have a feel for this, and I'd appreciate your view or the views of other people who are in practice. I don't quite understand why there has been such an explosion and an uncontrolled explosion of these cases, because it's always struck me that, at least as a matter of normative principle, the kind of reasoning which was forged in CART itself, where it was forged on twin premises. One premise was, yes, we want to have some JR backstop, but on the other hand, we don't want to have the normal tools of judicial review. We don't want to say every time you make any error of law, we're going to get in there and quash it, because it's the tribunal system, it's staffed by lawyers, etc. We're going to give them respect in accordance with the nature of the institution in question. And that was the premise behind the carving out of the special kind of rule for judicial review and CART. So my second point is, I've always been a bit puzzled about why there has been this, as it were, uncontrolled explosion of cases. I'm not quite sure why the court just haven't been turning the back at the court door saying, in limine, the arguments you're presenting don't get anywhere close to satisfying the CART criteria, or perhaps they do. Third point is that, and this harks back to something that Alison said and something also that David said. While I appreciate, as David said, that there are safety nets in the proposed section 11A, there are instances where you can still raise a JR case. My reading of 11A is that, although to some extent, putting it in David's terms, it's harking back to a sort of more visceral kind of jurisdictional error issue. In some ways it is, in some ways it isn't. What it isn't, in the ways that it isn't, is the way that was pointed out by Alison. In other words, my reading of 11A as it stands now is that the FTT and or the UT could have made a really foundational error of law, a really serious error of law, whether it's concerned with human rights or not. And you get no recourse. And that's gone. And I don't see anything within 11A as presently formulated which would allow you to bring an action in those circumstances. While I fully respect the upper tribunal, etc., and all of that I really do, it still seems to me that cutting out any such JR safeguard is a little worrying. Thank you.
Right, thank you for that. So next question, I think David's also answered this. So over to the other two. First, Alison, will the courts uphold the CART ouster clause? Because I don't think it's self-evident that they will.
It's one of those things where my guess is yes. And I think the reason they will is mostly because of the way that David has been explaining. It's not, there are so many aspects of this clause that mean it's easy to justify what they're doing here. So my worry is more, will you then, once this works, will you then start using it as a model in other areas where there isn't the same justification? So
you think it will succeed in other areas?
Yeah, and that's
if this model works, because I think it has been suggested that this might be a model for other areas.
Yeah.
Do you think, because if the court does uphold an ouster clause in this field, if you use identical wording in another field, how can the court, in a principled way, say, well, we uphold it for CART, but oh no, we can't uphold it if you take away another area from, I don't know.
Okay, I think you've got two ways of doing this. Sorry, Vikram.
No, go on.
The problem of delays. I think you've got two ways of doing this. So one is to read Privacy International carefully. So in Privacy International, we have a backdrop of various assumptions of when you'll interpret an ouster clause and how it works. And one area where there was some aspect of divergence spread on when does this apply? So does this assumption apply writ large to any ouster clause, or does it apply differently when you have an ouster clause that's dealing with a judicial function or a judicial power as opposed to an administrative function and administrative power? Now, if you're looking at the assumption of how you interpret ouster clauses to do with administrative powers, you've suddenly got 4-3 majority saying there is an assumption that you will read this in a narrow way and read it down. Where there's the divergence is Lord Jones saying, I'm not sure that applies when it's judicial. So suddenly you go from a minority to a majority saying you have to read this down. So I think because here you're dealing with a judicial function and you're dealing with what is in essence a court, That's very different from if you're dealing with something like the Foreign Compensation Commission or an executive body that doesn't have the same judicial function or the judicial element to it. So I think that's one way, which is to take the ratio of privacy international and make that distinction. I think the second way is drawing on the background constitutional principles and reading this and saying, well, maybe because there is some potential, if we read 11A4 broadly, to stop the major obvious, it wasn't to correctly compose as a fundamental breach of natural justice, or maybe even if I had the ability to kind of read in human rights things as well, which you never know, we might get there. I think then in those kinds of elements, you can kind of say, well, there's still some preserve for ultimate rule of law elements. If you start applying that to other areas where there's a stronger need to uphold the rule of law, so like David's example of what if this is just completely radical, undermining fundamental aspects of democracy, or what if this almost tips into the kind of scenario we saw in AXA and Jackson, where we say you're essentially removing judicial review writ large because you've done so many things and now ousted that essentially there's no real effective protection of the rule of law anymore. So I think partly scale, partly what are you removing and how important is that to the rule of law can be used to justify distinction on the background constitutional principles as well. So it might not be perfectly able to sort of pick this up and put this somewhere else and it still work, because I think you've got to think of ouster clauses very, very carefully and contextually to work out whether it's justified or not. And I think that's probably where the courts would go.
And someone said context is everything once, didn't they? Paul, what do you think?
Thank you. So two brief comments. One is that I think that if and when this comes before the court, I think they will let it go. They will uphold it. They won't strike it down. And my 2 points are related, so I think that they will. David has put on the table a whole series of arguments that I think that the courts would find relevant and of importance and compelling. And I think that they would uphold this one. And I think the parliamentary draftsmen were quite canny, and rightly so. And I don't mean that pejoratively at all, I really don't. I mean that they rightly put in certain exclusions and safeguards. They didn't leave them to be read in. The point about having the tribunal properly constituted, the point about a fundamental breach of natural justice, you've got qualifications there. It's not a complete, the door's not completely slammed shut. So that's for that concatenation of reasons, then I agree with David and with Alison that I think that if and when this is challenged, they will uphold it. The second reason I think they will uphold it is something which Alison has adverted to eloquently already, which is that I think they're going to be strongly influenced by the backdrop of who the decision maker is against which the ouster is operating. And it was very clear in the Court of Appeal in Privacy International and very clear in the dissent in Privacy International that they were very strongly influenced by the fact that the primary decision maker, in inverted commas in this instance, was a properly empowered and instructed judicial institution. And that is self-evidently the case in this instance as well. So I think they will uphold it for that reason as well. That then leaves the question, which has just been discussed, about, well, what would be the analogical application or potential analogical application of this type of ouster, where the decision maker is not of that kind. And it seems to me then you need to disaggregate or distinguish between two different kinds of institution. Maybe one would disaggregate even more, but at least two. One is the pure minister case, okay? You just have a statutory power given to a minister, and then they put into the primary legislation an ouster clause of this kind, which is protecting the minister in similar wording. I do not believe a court would buy that, and I think that they would distinguish it, and I think that they would distinguish it even if the wording were identical, and I think they would rightly distinguish it on the basis of the difference in the nature of the primary or initial decision maker in the two instances. The interesting sort of middle case is one which came up from an example which Alison gave, is what happens if the primary decision maker isn't a tribunal in the sense of the TCA and it's not a minister, but what happens if the primary decision maker is an agency? Okay, but an agency which really is an independent regulatory agency, which is making a decision in accordance with statutory criteria, and quite often may have, in certain instances, lawyers on the agency or even making the decision within the agency. I think that will be, a competition tribunal or something akin to that would be an example of that middle ground. And which way they would go in that instance, I'm not sure. Thank you.
Thank you very much, Paul. Just a quick word from you, David, about the second point about an ouster clause in an area other than CART. Do you think the courts would uphold that?
Like the others, I think it would depend very much on context. And I think that the context is not just all important, but I think it's constitutionally important as well. It strikes me that the sort of experience we've had with ouster clauses in the kind of body that Paul was mentioning is the case of Annis Minnick itself, because that was something between a tribunal and an administrative body, but staffed with lawyers and conducting its proceedings in a strictly judicial way according to rules of procedure. And there was disagreement within government about whether it should be regarded as an administrative body or a judicial body or something completely different from both of them. And the House of Lords, you've got one person saying this is a body composed of lawyers and it's very reliable, and then another saying it's an administrative function and an administrative body. But that sort of consideration is clearly important. In the end, in relation to the particular provision in the Foreign Compensation Act, which was a weak one compared with what we've got in the bill, it wasn't decisive, and it was, but where you have a very strong provision like the one in the bill, I think it may well take on far greater importance. Right.
Well, yes.
Vikram, could I get just one footnote observation on that? Just thought about that. I mean, it strikes me as one of the paradox. I mean, David's absolutely right. The Annis Minnick example is a great example, because of course that's exactly the kind of intermediate body that it was. What strikes me somewhat paradoxically is that if you've got a body like that and you whack in an ouster clause of this kind and you ask, should the courts uphold it or not? I mean, one response is, and this is the paradox, is that if you don't have the problem of the numbers game, which is driving, removing CART because of all the asylum and immigration cases, if the subject matter dealt with by that tribunal does not have that factual backdrop, then what one might be inclined to say is actually a CART type criteria for limited circumstances in which you should be able to seek judicial review from a body, an intermediate agency body of that kind, may well be a sensible kind of criteria, and that's the sort of somewhat of a paradox.
Right, thank you very much. Thank you very much, everyone. And thank you, audience, for having the patience to sit through all of this. I hope you found it enjoyable and informative, and I hope to see you at another seminar soon. Thank you very much, everyone. Good evening.